Good morning, everyone. Welcome to House Judiciary. Pierre, want to call the roll?
Representative Brady,
Here.
Representative Breton,
Here.
Representative Chestek,
Here.
Representative Filer,
Here.
Representative Kelly,
Here.
Representative Lean,
Here.
Representative Singh,
Excused.
Representative Webb,
Here.
Chairman Washut.
Here.
You have a quorum.
Thank you, Pierre. All right, Senator Hutchins, we have Senate File 77. Why don't you walk us through the bill?
Thank you, Mr. Chairman, members of the committee. Senator Hutchings, Senate District 5 here in Laramie County. Compelled speech is not free speech. This bill is a result of a constituent request. I got a call and they were concerned that in the workplace they were being forced to use particular pronouns that they did not feel comfortable with, and they said, hey, what can you do about it? So I had the LSO draft a bill last year. It made it out of the Senate, but the House didn't get a chance to hear it. So what this bill does, and it's really, really simple. You can try to turn it around, you can go this avenue, that avenue, but it's simple. It's a matter of the government cannot tell you what you can say. So with that, an act relating to the administration of government prohibiting the state and its political subdivisions from requiring the use of preferred pronouns, authorizing a civil remedy, and providing an effective date. On page 2, we have the state and its political subdivisions shall not compel or require an employee to refer to another employee using that employee's preferred pronouns as a condition of continuing or commencing employment, or contracting with the state or its political subdivision as a condition of receiving grants, loans, permits, contracts, etc., under threat of adverse action by the state. Any person aggrieved by violation of subsection A of this section may file a civil action and in any court of competent jurisdiction. Now, during testimony on the Senate side, I was asked if the original language in the bill was, I forgot what the word was. I forgot. But anyway, they took out a portion of the bill that I think is very, 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 very important for the bill. And maybe we can get someone to deal with that later on. But pretty much, Mr. Chairman, members of the committee, the government can't tell you what to do, or say, should I say. And that is the bill. I sit for questions.
All right, Senator, so the bill appears to address employee-to-employee dialogue.
Pretty much.
And then on page 2, lines 5 through 7 and 9 through 11, it seems like we drift off into relationships between employees and perhaps contractors and licensees and, other benefits and so forth. Can you explain how those paragraphs relate to an employee-employee communication?
All right. Based on what I get from the way the LSO drafted it, first of all, the state can't force the employee to use a pronoun, and then they can't say, well, you can't do this. If you don't do this, then as a condition of continuing employment with us, we can fire you, whatever. So that's where that's coming in. It's kind of a restriction on the employer from saying that if you don't do this, we're going to do that. And we do have a a case here. Unfortunately, we have 2 cases here in Wyoming since this bill was drafted, where 2 citizens have lost their jobs, unfortunately teachers, because they refuse to use the preferred pronoun. So this action is indeed happening, where as a condition of employment or receiving grants, whatever, if you don't use these pronouns, the way we tell you, then you can be fired or lose these grants and loans.
Representative Feiler.
Thanks, Mr. Chairman. Senator Hutchings, I understand those two court cases. My wife works for a school district. And I know as a parent too, when I fill out the paperwork to enroll my child in a school in our district right here, Laramie County, there is a spot there for the parent to decide what that name, or, if Johnny's got a nickname, instead of using Jonathan, they might use Johnny, right? But those things are in place, and those teachers have to abide by what is on that paperwork. They can't, the teachers are not allowed to actually, in our school district, to say, well, we're gonna call Johnny whatever else. They have to go by that paperwork. So there is some safeguards right now, Senator, I believe. If it's different, let me know, because I wanna make sure that we're not calling somebody that they're,
Right.
they don't wanna be called that, or I just wanna make sure we got some safeguards in there.
Mr. Chairman, thank you. And I agree with that. And according to the case of, I think it's Clemenston here in Laramie County, Representative Feiler, he said he was doing the roll call. And the student said, I want to be called this. And the substitute teacher said, I have to go by what's on the roll. If you want to change your name, then that's something different, and the parents can do that. But in this case, he was let go. Actually, it says he was dragged out of the school for not using the preferred pronoun.
Representative Kelly.
Thank you, Mr. Chairman. I'd like, if I could, have some clarity on how this bill would interact with employer anti-harassment policies. Let's just hypothetical. Let's say there's an effeminate man who goes by he and him, but a coworker insists on calling him it or she is a form of harassment. How would this affect a situation like that?
Senator.
Mr. Chairman, this is the road that I want to try to stay away from. And I'll answer Representative Kelly's question, but this is the issue. It's not a matter of what you say, it's a matter of the government telling you, you have to say this. So with that said, we have the Bostock, Clayton County case where two men, based on their sexual proclivities, were fired. And for some reason, WEA thinks that EEO now says, okay, you can't harass people in the workplace. This has nothing to do with harassment in the workplace. In fact, it kind of evens the playing field, where the person who says, I don't want to say that, isn't harassed because they now have to say something the government wants them to say. So let's take that out of the equation, because it doesn't belong in this bill per se. It's nothing to do with harassment. If you're harassing someone, you should be reprimanded. So that's as far as I want to go on that one. Thank you.
Representative Shestak.
Thank you, Mr. Chairman. Senator Hutchings. Section A on page 2 says the state cannot compel. Suppose there's a business that wants to be known as inclusive, and the employer says it is our policy. The state hasn't compelled them, but it is our policy to use people's preferred pronouns. Can the private employer who wants to have an inclusive workplace have a work policy saying my employees shall use other people's preferred pronouns? Is that okay?
Representative Hutchings.
Thank you, Chairman Washit.
Senator Hutchings.
That's okay. Representative Chestik, good question. Private businesses can do what they want. When you go and to get hired, you go through an interview, I'm sure the employer is going to tell you what their policies are. And if it's a private business and I want to work there and this is what they prescribe, then guess what? I have to do what they require because that's what their employer says. This is what we're calling the state. not a private employer. So again, keep it on the state telling people they have to say something, and that's all this bill is saying. Our First Amendment rights to free speech, we're going to try to keep those intact. Thank you, sir.
Representative Brady.
Thank you, Chairman. I'd like to speak to what was mentioned earlier. A legal name on a roll where a student's registered, a teacher is required to call out that name. They're not required to call a nickname. They may, but they're not required to. And if John wants to go by Johnny, that's not a pronoun. And a pronoun can change depending on how a student or staff feels, at a particular time. So I just wanted to mention that. Thank you.
Representative Filer.
Thanks, Mr. Chairman. Senator Hutchins, on page 2, starting on line 9 there, it says, as a condition of receiving a grant, loan, permit, contract, license, or other benefit afforded by the state and political subdivision. So I deal with permits a lot. I deal with contracts a lot. I'm just trying to think of how a permit, this bill would have anything to do with a permit. Like if you pulled a building permit, right? Because permit is, part of a state, or it's awarded by a state or a political subdivision. A building permit would have no, I think on the private side, pulling the permit, I don't know if the government should have any control of how they word their permit for them, unless this is just a permit that we're giving to somebody to do work for a state. I mean, I think we're getting into some weeds with some contractors and all these other things on private business. I don't know if you could just help me with that, Senator Hutchins.
Senator.
Thank you, Chairman Washat. Again, you're taking it into the weeds. This is the way LSO drafted it. And what it's saying is, Representative Filer, you refuse to use certain pronouns and you work for the state. Well, guess what? You can't get a permit now. So it's LSO who drafted that in. It's not it's kind of like, this is a punishment to you. We're not gonna do this for you, this, if you refuse to do what we say. That's all it is, and it's simple. You can take it there, but don't. Yeah.
Representative Filer. follow up.
Mr. Chairman, Senator Hutchins, but that's what it does on that, because it is, if you're receiving a grant, a loan, a permit, or contract, or license, or other benefit afforded by the state or political subdivision. But it actually does take the private enterprise and actually regulates the private enterprise on receiving a contract or a permit or a license. A license can go anywhere from an electrical license to other contracting things, I think, but that's exactly what this does. I mean, in receiving a grant or a loan, we're mixing private with public here, Senator Hutchins.
So Representative Filer, I think, take a look at lines 1 through 3 on the top of that page.
Thank you.
So there we're talking about an employee to an employee. Right?
But
That was my first question.
But Mr. Chairman,
Representative.
part 2 or line 9, I understand it says that in that part, but this is gonna add it into the green books. We don't, a government doesn't grant, well, they do grant permits, but permits are to private enterprise, not to another government entity. Unless, I mean, they might make a contract with another government entity to do some, work, but as far as permit, because it says the state or any public or political subdivision, that's where I'm worried about. I just don't want somebody to get denied a permit or a contract through a political subdivision because they want to use their pronoun, if that makes sense, and get into the private side. But it will add that in there. I mean, I'm not an attorney. I'd love an attorney to help me with it, but.
Senator.
Thank you, Mr. Chairman. Representative Filer, again, I look at lines 1 and 2 and 3, and it says, as a condition, of receiving a grant loan permit, contract, license. If you want to strike permit out of there, I wouldn't have a problem, but I don't think it's going into the area you're thinking. But if it makes you feel better, this is the way it was drafted by LSO, and I think the attorneys, and we've looked at it over and over, and we've had other people look at it, and you're the first one that's brought that particular instance up, because I think they're staying on the track that we're going on, and that is, you cannot say that Representative Filer, Mr. Chairman, cannot receive any permits from our state because he refuses to use an employee's preferred pronoun. And
So
that's
let-
all it
Senator,
is.
let me ask you this. So let's say I'm an employee and I work for agency B and I refuse to use agency-directed pronouns. And then I apply for a permit or something from another state agency completely outside of my employment. But the word has traveled over to agency B while I'm applying for a permit, and this is a penalty for my having refused to use pronouns in agency A, so now agency B refuses to issue me a permit as an employee. But we'll all go back to that first three lines. This bill's about employee to employee. It's not about employees to private businesses who are seeking permits and those things. This only affects, does the state retaliate against an employee who refuses to use the proper pronoun? Representative Chestick?
Perfect.
Thank you. I share Representative Filer's concerns about that section, but I'll leave that aside for potential amendments. This bill actually does go beyond employee to employee. It also covers potential employees, applicants, right, under Romanet I, as a condition of continuing or commencing employment. So somebody commencing employment is not yet an employee, they're a potential employee. So my question to you, Senator Hutchins, is suppose I'm a school principal and we're interviewing jobs for teachers, and an applicant comes up and says, volunteers that I do not want to use people's preferred pronouns. I'm going to refer to people by what they look like.
Or their name.
Okay, and so the principal says, well, that's not the attitude we want to have in our teachers, so you're not hired. Is the principal now liable because the potential employee, the applicant, volunteered that they don't want to use other people's pronouns?
Senator?
Mr. Chairman, in that case, I'd be hard pressed to say really, but what it sounds like is if an employer is willing to say that to an employee and an employee is willing to say that to that person, I'd be hard pressed to know for sure. When they're commencing employment, I think if you're willing to express that and he's willing to express that, then he'd be in violation because he works for the state. And he's saying, as a state employer, I'm going to force you to say that, or you're not going to get hired. That's the case that we're looking at. And if we can just keep it on that, then I think this is very easy to understand.
Representative Lee?
Thank you, Mr. Chairman. Senator Hutchings, thank you for coming today.
Thank you, ma'am.
In regards to all of the conversation from lines 1 to 12, I just want to ask, would you agree that this is a right-to-work state and that you always have an opportunity to accept or decline a contract?
Senator?
Chairman Washit, Representative Lean, yes, ma'am.
All right. No further questions to you? Do you have other witnesses that you brought with you perhaps or not?
No, sir. Oh, there might be some on Zoom.
Okay. So is there anyone in the room wishing to testify on Senate File 77? Anyone in the room? Don't see anybody. Can we bring in Ms. Burlingame, please? Good morning, Ms. Burlingame. You know the drill. Introduce yourself and then tell us what you want us to hear.
Good morning, Mr. Chairman. Good morning, committee. I'm Sarah Burlingame, Executive Director of Wyoming Equality. Thanks so much for letting me join remotely from snowy Teton County. Wyoming Equality is in opposition to this bill. I think you guys have had some great conversation about it so far. We would just underline that in the absence of the state mandating chromosomal or genital checks, all pronouns are preferred pronouns. And I understand that the bringer of this bill and others have concerns about being compelled to sign on to language or nomenclature that doesn't align with their beliefs. But I would just remind everybody that what has served us thus far are our own good manners and our own sense of decency. And the state hasn't had to mandate any of that. We have just seen fit to treat each other and name each other as people have preferred. In the absence of that, and if you look at the plain language of this bill, this is not like going into the weeds. This is just the consequence of what this bill will institute. Folks who have noted that this could lead to bullying and harassment and saying, you may have a preferred pronoun of he and him. You may have been raised a boy and know yourself to be male your whole life, but I, your colleague, am going to choose to call you a female. I'm going to call you she. I'm going to call you it. And I don't have to use your preferred pronouns. That's my right. And I would say that nobody intends for that to happen, but I think that things do absolutely get muddy when we start compelling this kind of speech. So I hope that folks will take a look at some of the unintended consequences of this bill and ask themselves if the state is the right agent to start determining how we treat one another in the workforce. And if we can't go back to what has worked very well in the past, which is a common sense of decency, good manners, making people feel welcome, making them feel like we listen to them, those are the things that have worked well for us in the past. And I would urge folks to reject this language and go back to what works. And I'm happy to stand for any questions.
Committee, any questions for Representative Burlingame? Representative Filer?
Thanks, Mr. Chairman. Mrs. Burlingame, I would, I don't know if I'm pushing back, but maybe ask a question of if this bill passes, I believe it could take away a way of bullying in a way, because, you know, we're gonna call John, John, right? There's no other words to use in this bill. So I think it could possibly eliminate some bullying, because if somebody wants to use different pronouns and those types of things, it could open it up for other people's perception, their ideology, all these other things. So I think it might help kind of close it in and maybe eliminate some bullying too. I could kind of see it both ways, but if you could speak on that, Mrs. Burlingame.
Ms. Burlingame.
Mr. Chairman, Representative Filer, thanks. That's a great question, because we had that conversation in our office too, right? Like, could we use this to say, hey, this is my pronoun, this is what it says on, you know, my amended birth certificate or whatever, and now the state is actually giving us the power to enforce that. But I would say, going back to what what I opened with, right, which is that all pronouns are preferred unless you're willing to do a chromosome and genital check, right? So we have folks who have transitioned their gender from the gender that they were assigned at birth, living here in Wyoming, working here in Wyoming. They have amended birth certificates, they have driver's license that affirm that they have transitioned their gender over. So you would open up a scenario where an employee said, doesn't matter, I don't care what your birth certificate says, I want to see a chromosome, I want to see a genital check. And I think you can understand what a nightmare that would be in the employment sphere, where we have seen this probably, come to fruition the most, and particularly in Utah, but in other states, is when the state starts policing gender this specifically. You take girls who are real athletic, who play sports at a high level, and you have adults saying, I want your daughter to have to undergo some kind of genital check. I want to be reassured that they are who they say they are. And I know for a fact that the bringer of this bill would never want that to happen. I know that that is absolutely beyond the scope of what is intended, and what is intended doesn't really matter when what this opens the door to. So, Representative Filer, I would say that that may not be the intent, but unless someone can say, how would you determine that outside of a chromosome or a genital check? I think this committee has to reckon with the fact that that would be the reality.
Okay, thank you. Pierre, can you bring in Ms. Nolan, please? Follow up.
Thanks, Mr. Chairman, and I won't take too long on this. Oh, Mrs. Burlingame, you mentioned all the different things, where maybe a birth certificate's amended and all those types of things. But if somebody does go through a transition, and they, say they're now a female, not a male, and they change their birth certificate from Travis to Tracy, then we're just gonna call that person Tracy. That's how I kind of read this. If I don't think the state wants to do any genital checking or anything like that on anybody. I think it's just when you show your documents for proof of employment, it's gonna say, on your birth certificate or your social security, all those different things, a name. And I think that's the name that we want to get to as far as a state to make sure we're not going down a path of opening it up for a bullying situation. Thank you, Mr. Chairman.
Thank you. All right, Ms. Nolan?
Good morning, can you hear me okay?
You're a little soft. Speak into the microphone and state your name for the record and then tell us what you want us to hear.
That sound a bit better?
Yes, that's better.
Wonderful. Good morning, Chair and members of the committee. My name is Sarah Beth Nolan, and I serve as legal counsel with Alliance Defending Freedom. This morning, I'd like to talk about some of our cases, people that we have litigated on behalf of who have been affected by this issue, like our client, John Klug. Mr. Klug is a high school orchestra teacher in Indiana. He is engaging and loves his students, and in fact was awarded for leading his orchestra to perform better than they ever had before his employment, and was faced with a difficult situation where he was faced to be forced to speak on behalf of the school district on gender ideology. And Mr. Klug is a deeply religious man who believes that following that policy would have forced him to violate his core beliefs. And so Mr. Klug approached the school district for a reasonable accommodation. He asked that he would call all students by their last names only, which would allow him to stay neutral on this issue and focus on being a music teacher. And his school district at first granted that reasonable accommodation. But unfortunately, after a few people grumbled about it, the district ended up revoking that accommodation and forcing Mr. Klug out of his job. Some more of our clients, Peter Blaming, a high school French teacher in Virginia who was fired for declining to call someone by male pronouns. And then another one of our teachers, Vivian Garrity, she's a middle school English teacher in Ohio, was forced to resign because of this same issue. And like the sponsor mentioned, there are several instances of this coming up here in the state, in Laramie County and in Sweet County School District 1. And so I'd like to speak to the legality of this bill. One of our most fundamental rights under the First Amendment is that under our freedom of speech and freedom of religion, that includes the freedom to not endorse a message contrary to our beliefs forced by the government. And that is why we are seeing a growing number of federal courts that are ruling on this issue of pronouns against the state or government officials forcing government employees to violate their sincerely held beliefs and endorse radical gender ideology to keep their job that they don't actually agree with. I'd like to quote out of Peter Flaming's case, the court there, he said, and I quote, teachers cannot be compelled to be a mouthpiece for controversial religious, political, or ideological causes, end quote, nor can the government coerce the people, quote, into pledging verbal allegiance to ideological views that violate their sincerely held religious beliefs, end quote. I think that we can all agree that words, including pronouns, they have meaning. They carry a message and they speak to our identity. And we would never look at a teacher and force them to respond to a student saying, for example, around Easter time, Christ is risen. Christ is risen indeed. If doing so would force that teacher to affirm a belief that they do not agree with. And the same goes for pronouns. This bill it's very basic to protect government employees from having to force them to agree with something and to verbalize that agreement in order to keep their job. And so if I may, I'd like to provide clarity on one of the questions that was given earlier on how this would interact employee to employee. And this simply says that the employee for the state has the right to refrain from speaking. It does not prevent someone from providing their pronoun or speaking about these issues. It simply says that if someone would like to refrain from participating, that they are allowed to refrain. Thank you, and I'm happy to answer any other questions that you may have on this.
Committee, any questions from Ms. Nolan? Seeing none, thank you for joining us today. Appreciate your testimony.
Thank you.
Anyone else? Pierre, anybody else out on Zoom? Anybody else in the room on? Please come forward. Good morning. Please introduce yourself for the record and then tell us what you'd like us to hear.
Good morning, Mrs. Chairwoman, members of the committee. My name is Sophia. I'm a student at the university, and I'm just here to urge you to vote no on this bill because it explicitly allows for bullying and disrespect. And I would argue that those things are already plenty legal. 1 in 5 students report being bullied in their schools across the country, and I don't think that we should encourage any more. Mrs. Chairwoman, this bill would make it illegal for you to ask me to correctly and respectfully use your preferred pronouns. That's all. Thank you.
Questions? Thank you for joining us this morning. All right. Anyone else wishing to testify? All right, committee, what's your preference? Moved by Bratton, second by Webb. Any amendments?
Mr. Chairman?
Representative Filer.
I feel, maybe I just need, I understand 1 through 3, but I'm thinking about that on lines 1 through 3 on page 2, but I understand that part. But lines 9 through 11, I just want to somehow, I don't know if we should make an amendment or not, but I need to feel really strongly that we're not isolating private enterprise on that permitting and contract or license part. So, and then also on that, on line 11, the political subdivision, if we was to pass this law, that pretty much we would tell every town, county, or any political subdivision, they have to abide by the same exact law the state does. So we're kind of taking some of their local control away on that one. Of course, you know, municipalities aren't here today to testify on this or want to testify on this, so I don't know if they might not even have a problem with it. But if to make me feel better, I would like to scratch or you know, run an amendment that says on line 10, we delete permit, contract, or license and or. Or how would I write that?
Leave or in.
Yeah. And then strike political subdivision, or just strike lines 9 through 11 completely. Just because I don't have the assurance committee that this doesn't,
Okay, so the motion is to strike 9 through 11.
yes. And
Is
if,
there a second to that motion?
I'll second for discussion.
Second for discussion by Chestic. Discussion. Representative Lane.
Thank you, Mr. Chairman. I would be on and against the amendment, as every contract that the state provides is an at-will employee at one time for us. And so we want to make sure that those at-will employees that are within our state buildings are abiding by the same rules and laws that our state employees do.
If you read 1 through 3 and then read the next section, the state and its political subdivisions shall not compel or require an employee to refer to another employee using that employee's preferred pronouns as a condition of receiving a grant, loan, permit, contract, license, or other benefit afforded by the state or political subdivision. So if you read it in conjunction, you get the context that this is one employee being denied a grant or an employee being denied a permit because of their pronoun issue. Did that help understand this, Representative Filer?
Mr. Chairman, it does. But I'm just trying to think if that employee, so you got 2 employees, and one owns outside of their work in the government, maybe they own a little contracting company. But when they apply for the permit, maybe I'm getting into the weeds. And you know what, Mr. Chairman, I would like to pull my amendment and then maybe talk with LSO and some other attorneys, make sure I'm just doing this right. Because I don't want to weaken the bill to the point it doesn't work correctly. So I make a motion to pull my amendment, Mr. Chairman.
Representative Chestic.
As a seconder, I'll agree to withdrawing that, and I'll propose a different amendment.
Representative Chestic.
My amendment is simply on line 10, delete permit, contract, or license. Because I'm having a hard time seeing how that would ever happen. So the state, I'm sorry, if there's a second, I'll discuss it if there's a second.
Is there a second?
Second for discussion.
Second for by Filer. Further discussion?
Thank you, Mr. Chairman. So the state conducts business, and its political subdivision conduct business by hiring people, or sometimes they contract with people, or they give out grants. So I can understand, but a permit is something that a private individual has a right to, and the state can't condition. I don't see how the state would ever condition the grant of a permit or a contract or a license by saying, we'll only give you that permit, contract, or license if you agree not to use somebody's preferred pronouns. I don't understand how that could happen. It just seems completely mixed up to me. And it does, I think, blend private industry with public benefits. Those permits, contracts, and licenses should stand on their own merits, whether you use preferred pronouns or not. So I would like to strike those 3 words.
Further discussion, Representative Bratton.
Thank you, Mr. Chairman. I believe that the lawyer from the ADF brought up teaching licenses was a primary example. And I'd also like to, again, direct that question to Senator Hutchings to respond to that.
Senator Hutchings.
Thank you, Mr. Chairman. Representative Bratton. To me, it's very clear. And when the representative has a problem saying, or has a question saying, I don't see the state ever doing this, then I think he's correct. They probably never will. So that's the answer to my question, or his question and yours. Thank you.
Further discussion on the amendment? Seeing none? Chair, you have the amendment. We're striking permit contractor license from line 10. All those in favor of Representative Chestic's motion, say aye.
Aye.
Those opposed, no. No. The amendment has failed. Further amendments, Representative Filer.
Thanks, Mr. Chairman. Also on page 2, on line 6, I would like to strike contracting. And so it would just read, as a condition of continuing or commencing employment. Actually, we'd strike or contracting with the state, so it'd be employment with the state or political subdivision. And if I can get a second, I'll explain why, Mr. Chairman.
Second by Chestic.
Okay. Mr. Chairman.
Discussion?
Yes, the reason why I would say contracting is our state does contract with a lot of larger contractors, whether it's for road work, whether it's for building maintenance, also other political subdivisions hire other contractors too to do a lot of our maintenance on our buildings and things like that. So the reason why I would want to strike that is because I don't know if the state should be, I know this is employee to employee, but contracting with the state or political subdivision, because you could be an at-will employee and still be a contractor, because you're getting a contract through the state to do a job. So are we telling that company that they cannot use pronouns or anything like that in their company? Otherwise, they're considered a contracted employee through the state. Maybe, I just want to make sure we cover all of our bases here, Mr. Chairman. So if anybody could help me with that, explaining, I understand 1 through 3, but employment or contracting, that's 2 different things. Employment is we're employing people. They work for the state, but contracting for the state is another whole big entity here.
So I think, from my point of view, we're talking about an employee who might also have a contract with the state. So maybe you're a clerk in one agency, but on weekends you mow grass for White Otter or something, right? And so the agency then discriminates against you because of your non-compliance with this topic. You know, the state demands that you use pronouns, you refuse, and so then you lose your contract to mow grass on the weekend. I think that's what this is getting at, that rather than, affecting other contractors. You would have to be a state employee who would also be contracting, is the way I read it. Representative Filer.
Mr. Chairman, and I understand that part, I do, but we're creating new statute. So, and if you was to read this, I mean, I'm no attorney, but if you was to read this, contracting is pretty broad. It's not just, contracting could be very minimal or it could be very large. And if we are contracting, the way I would read this, and I'm not an attorney, but if I was to read this, you are contracted through the state to build this building. You have to abide by this in your private enterprise, or you could be fired, is where I'm reading this.
I don't think that's a correct interpretation, Representative. You'd have to be a state employee in addition to being a contractor. So if you're a state employee who also happens to have a contract to build this building, and the state said, we're not going to give you that contract to build the building because of your position on pronouns. And so then you would be harmed as an employee by the denial of the contract, not because you're not a good contractor, but because of your position on the pronouns. Representative Filer.
Thanks, Mr. Chairman. So what we're telling our state employees then with this is, if you have your own business outside of the employment of the state of Wyoming, you will abide by this, even though your business has, it's its own entity, it's not the state. But we're telling an employee that works for the state, if you own another business outside here and you end up with a government contract in any political subdivision, that you have to still abide by the state's rules with your own company. Mr. Chairman, that's what I think you just explained to me. Because they were an employee here in the state of Wyoming, but they have a business outside of here, we are going to take and regulate private enterprise on that person's own business because they have a state job or any political subdivision.
I disagree. I think what we're getting at here is that the state can't punish that employee. Okay? So you have employee A, who's a clerk in some state office, and they mow grass on the weekends. Have a contract with the state to mow grass on the weekend, okay? Because employee in agency A refuses to go along and is mandated by their employer to use pronouns, and they refuse to go along with the pronoun stuff in agency A, they're then punished by losing their contract to mow grass on the weekend. So we're not compelling that the grass mowing company have any particular pronoun policy for other grass mowers. We're simply saying that the state can't discipline that employee, and we discipline them in a way by denying them that contract to mow grass. If the reason we're denying them the contract to mow grass is their unwillingness to refer to somebody by a designated pronoun. Representative Filer, or Representative Lean?
Thank you, Mr. Chairman. On and opposed to the amendment, for you see, if we strike contracting with the state, the very best part of being a business owner is that these contracts all come with terms and agreements, whether you're contracting with the state or contracting with a large corporation, that you have the choice to accept those terms or not. And if we accept this amendment, we will be putting a difference for unfair treatment between our full-time employees and our at-will employees. And I don't think that we should create that division.
Representative Chested.
Thank you, Mr. Chairman. On and in favor of the amendment. I think Representative Filer is on to something here that I hadn't thought of, but I think what I'm concerned about here is the state puts out a bid saying, we're going to build a building, and we're going to require, as a condition of entering this contract with private company A to build a building, we're going to require that company to have a policy in place that you're not going to be able to demand that your employees use somebody else's preferred pronouns. So you're implementing the Part A as a condition of contracting with us, you shall not require your employees to use preferred pronouns. I think there's a reasonable interpretation of this bill that would require that. So you're imposing on a private entity who might contract with the state the requirement that you cannot force your employees to use another employee's preferred pronouns. I think you can interpret it that way. So in that regard, I'm in favor of the amendment.
I would think that you would have to ignore lines 1 through 3 in order to reach that conclusion, but you're entitled to your opinion. Further discussion. Representative Filer.
Thanks, Mr. Chairman. And if we vote this down, I totally understand. I do, because of lines 1 through 3. I totally get it. But I think what I might do now, I might work with the bringer, is it okay if we work with LSO and get a definition? We know what employment is. If we can get a definition added to this for what contracting is. And then that way we have that stipulated that we're not beating up private enterprise or private business. But if we can just add that definition.
Senator.
Mr. Chairman, Representative Filer, you've taken this way, way, way out of the way, what the bill is trying to do. But I'm willing to work with you. We will go to the LSO lawyers and we'll discuss this because it's just such plain, simple language. But like I said, I tried at the beginning. Don't take it there. But somehow you got there, and it's okay. I'm willing to work with you. Thank you.
Representative Filer.
Mr. Chairman, Senator Hutchins, one, I appreciate you. I really do, for possibly working with me on this. And And the reason why I did take it away there is because of what I do for a living. And so when it comes to permitting, contracting, all these different things, it's what I do for a living. So of course, those words stick out really hard on me. And I know, and I understand what contracting is, what permitting is, what's licensing, all those different things. So, but up or down, folks, I'll work with Senator Hutchins on this.
Sensing an urge to vote, Pierre, we have the motion is to strike the words "or contracting" on line 6, page 2. Committee, everybody clear on what we're voting on? All those in favor of Representative Filer's motion to strike "or contracting," say aye.
Aye.
Those opposed, no.
No.
That amendment has failed. Further amendments? Representative Bratton.
Thank you, Mr. Chairman. I think the harassment laws cover the kinds of things that Wyoming Equality brought up, so I'm comfortable with that. I do not think the state should compel speech, and in addition to that, I think that without the amendment that I'm going to propose, this bill would leave an injured party with no ability to be made whole. So within the original bill, there were compensatory damages, and I would like to add all that original language back into the bill. And people can lose their jobs, they can lose grants, they can suffer financial loss, and we need to put those teeth back into the bill. I want to protect our teachers. I'm a former teacher myself, and I want to protect those teachers from losing their jobs if the government compels their speech. So I've given that amendment and prepared that amendment. Thank you.
So you're proposing that amendment now, or are you going to bring it as committee of the whole amendment?
I'd like to propose it now. I am proposing it now.
Okay, so give us lines and language.
Just a minute, and I'll get that from the Pierre.
Only the chairman has, so. Okay. So Representative Bratton, can you articulate your motion, or do you want to bring it in committee of the whole, or which is your preference?
Let's see, so I think what was deleted was on page 3, line 7 through 20. I'd like to add those all back in from the original. Do you want me to read it? All right.
Original bill rather than the engrossed version?
That is correct. So Wyoming Statute 1-39-104, granting immunity from tort liability, liability on contracts exceptions. A governmental entity and its public employees, while acting within the scope of duties, are granted immunity from liability from any tort except as provided by Wyoming Statute 1-39-105 through 1-39-112, 1-39-122, and 139-123, and 9-14-601. Any immunity and actions based on a contract entered into by a government entity is waived except to the extent provided by the contract if the contract was within the powers granted to the entity and was properly executed, and except as provided by Wyoming Statute 1-39-120B, the claims produced of Wyoming Statute 1-39-113 apply to contractual claims against governmental entities. I also.
Is there a second to the motion?
Oh, sorry.
Second by Lane. Discussion on the amendment? Representative Chester.
So I think what's going on here is all of that language you just read is existing statutes right now. And we don't have to add it back in because it's still there. The only thing that is added in that section is adding section 9-4-601 to the list of things that are exceptions from this list, right? Am I interpreting that correctly? So all we're doing is saying government entities are immune except for certain things, and this is one that they would no longer be immune for. Is that correct?
Representative Bratton.
Mr. Chairman, yes, and there's also after 1-39-122, I think we had a comma,
Well, yeah, that's just,
and then and, yes, correct, thank you.
it's just correcting the list to be grammatical.
Further discussion on the amendment? Representative Filer.
Thanks, Mr. Chairman. I would like, Senator Hutchins, is that part you were talking about that got deleted out, and then you think it still gives it a lot better teeth in the
Senator.
bill?
Thank you, Mr. Chairman, Representative Filer. I think the best way to handle this is just take the bill back to its original form, because there are little conforming things that need to be done. And yes, this is so important. And on page 2, lines 19 through 23, and on page 3, 1 through 3, there were some changes there. So if Pierre would draft the bill to just be the original bill, I think it would clarify
All right,
everything.
Senator, let's stay on the amendment before the committee.
I'm sorry, sir. I'm sorry. Thank you.
Very good. Representative Bratton.
Thank you, Mr. Chairman. Yes, I would like, can I also add, I know on page 2, line 23, before the word injunctive, insert appropriate relief, comma, including, page 2, line 23, before the word injunctive, insert appropriate relief, comma, including, and then after the words declaratory relief, delete the period and replace with compensatory damages, reasonable attorney fees, and court costs. Yeah, because the compensatory damages are not punitive, they're restorative, and they have to be proven with evidence of financial loss. So for like the teachers that were fired, that would provide that.
Pete, hang on. Pierre, you have that? All right, Representative Chester.
Thank you, Mr. Chairman. I'm not sure if that's an addition, a new amendment, or the one we're still talking about, but just in the interest of time, may I make a suggestion that we deal with this as Committee of the Whole amendment? We give it a little more time for us to develop the language of the amendment. It'll still come up at the same time in Committee of the Whole, but it might just be easier to handle as a Committee of the Whole amendment.
Representative Bratton, your preference
Mr.
is your
Chairman,
amendment?
no, my preference would be to run this language in committee that brings it back to the original bill. So when the original bill comes out on the floor, then people can see that, and if amendments need to be made there, then we can amend, then that's where that could happen.
Either way, the whole body's going to have to vote on it, whether it's a standing committee amendment or a Committee of the Whole amendment. Either way, we get the same. But I just think it's going to be easier. We'll have more time to think about it and understand it before we have to vote on it here on the spot. I just feel it's not going to slow anything down. It's not going to change the time for when the amendment's adopted or considered by the full body. So just my suggestion.
So Representative Lean, you were the second. I just want to make sure you're good with the additional language that we've been adding on. Okay. So we're basically taking it back to the original version of the bill, is what the proposed amendments do. Even though if you have your computers, you can pull up that original version. Everybody clear what we're voting on? All those in favor of Representative Bratton's motion, say aye.
Aye.
Those opposed, no. No. That Motion carries. So we're back to the original version of the bill. Further amendments? Seeing none, call the roll on the original version of 77, Senate File 77.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestek,
No.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh, Aye. Representative Webb,
Aye.
Chairman Washit.
Aye.
8 ayes, 1 no.
All right. Representative Bratton, you'll have it on the floor. Now we're ready for Senate File 6. Senator Anderson. Good morning. So this bill started off as your bill a long time ago, last summer. Why don't you kind of set the stage for us a little bit, if you would?
All right, if I could, and I realize this is a whole new committee from the summer, from the interim committee, so I'll go back to the basics, if you don't mind. A constituent of mine came to me, and she has numerous houses in Casper that she owns and rents, and she came to check one, and 5 guys had moved into her house, said they had paperwork that they'd bought the house, and of course they didn't. They were squatters, is what you call them. She was brave enough to push them down, and she told them she was going to go get the sheriff. She went and got a friend of hers who was a rather big guy, and came back and they were all gone, but they'd done a lot of damage to the house. So she was all upset about that because she couldn't get the sheriff to help her because it has to be a civil matter instead of a criminal matter. So she was pretty upset that she would have to go through a month or two to get the civil deal done to kick him out. And she didn't have to do that, but she would realize that that would be a bad episode. So we worked on it a little bit, and at the same time, Florida introduced a bill to get rid of squatters and make it a criminal offense. And so one of the lawyers here checked with Florida to see what their bill was. We took their bill, made it a Wyoming bill, and that's what you have before you. The interim committee did a lot of work on it and fixed it so it's a lot better bill than what I had. It's interesting that I thought it was kind of an isolated deal. I talked to the realtors, the statewide realtors, and they put out a notice to their realtors, and they found out every major city in Wyoming had the same problem. And most of them did not go to a civil matter. They went in and asked them to leave, and they did leave. But we think we're going to be seeing more of this, especially in the capital city here. But every city in Wyoming had that same problem. So we got that bill together, and we realized it would be better if it was a committee bill, so I brought it to the committee. Since then, commercial and industrial have contacted me. They want it on the bill, but we did not change it. We left it as a residential bill, but we'll probably bring back a commercial and residential, or commercial and industrial. They've got people moving into their sea containers, moving into their empty buildings, and they're not kicking them out. They just know they're there. They haven't tried to remove them, but they have no way of removing them either. They have to go to a civil case. So this just makes it a criminal offense. So if you have a squatter, you can call the sheriff or the city police and they will come and help kick them out. So that's what this is all about.
Thank you, Senator. Representative Kelly.
Thank you, Mr. Chairman. Correct, I am one of the new people, and I've looked at the old transcripts, and I just need some clarification on why existing trespass laws are not sufficient to remove squatters in such cases.
One of the problems.
Senator.
Oh, sorry, Mr. Chairman. One of the problems that we identified is they're not identified as trespassers. They're identified as tenants. So it doesn't fall under the trespass laws. So that was our first thing too. We thought that would work, but it won't work because they're not identified as trespassers.
Representative Filer.
Thanks, Mr. Chairman, and go with Representative Kelly's question, and also you is, I've had the same type of situation. I had a house that I was remodeling, and over the weekend, somebody decided, looks like a nice house, right? So they went in there. I had no on the trespassing side of it. Once the person that goes into the dwelling, they can establish residency in the state of Wyoming almost immediately. So all they gotta do is pretty much say, hey, I live here, and then it becomes a civil matter, so it's really hard to remove them. I was fortunate in my situation, I got them removed really quick, but this is a real problem, and I would like to talk a little more about the commercial side of it sometime here. Thanks.
Mr. Chairman,
Senator.
another thing that happens is they do a lot of damage. And I think you have another bill that makes it a felony to do the other paperwork, to do the illegal paperwork, and then to bring charges for the damages that they do. Now that probably doesn't work because you can't identify who they are and you can't find them, and they don't have any residence. So it's kind of hard to collect on the damages, but that was one of the things we heard statewide, is that the damages were the big issue.
So Senator, you may or may not want to weigh in on this, but I raised this question during the interim when we looked at this bill, and it deals with the change to 63201, which is the property destruction statute. And it makes it a felony punishable by imprisonment not more than 10 years or a fine of $10,000 or both if the person unlawfully detains, occupies, or trespasses upon a residential dwelling and who knowingly defaces, injures, or destroys property or in the residential dwelling, in or on the residential dwelling, regardless of the cost of restoring the injured property. And so I guess what I want to be sure we're dealing with here is damages in the interior of that property. Because this opens up the whole destruction of property statute. This is separate from squatting, right? This is damage to property. And what I worry about is that if we're not really clear when we talk about in or on the residential dwelling, that somebody trespasses on your real estate, not necessarily occupying a structure, but they cause some minimal amount of damage. I think the example I used in committee was they step on your flowers, right? And we're going to make that a 10-year felony unless we're really clear that this is only talking about damage caused by a squatter inside, because this statute on damaged property can be enforced aside from squatting if we make these changes. So is it your understanding that we're talking about only damage when we talk about in or on a residential dwelling, that we're talking about damage to the interior of somebody's property? Senator?
Mr. Chairman, that wasn't my verbiage, but I like it. I think it should be in or outside, because a lot of the damage is when they're leaving, they throw a rock through the window. It isn't just the interior that they're destroying. They'll destroy anything when five guys walk away and get thinking it's pretty cute to break down a door or something like that. So maybe that does need cleaned up, so it just says when it's a squatter situation. I don't know.
Yeah, because on page 2, it says a residential dwelling means a dwelling or property, real or otherwise. And so that's my concern, is that somebody, is out, steps on somebody's plant and causes, damage to a flower. We're gonna make that a 10-year felony. And I don't think that's the intent, nor do I think any prosecutor would actually pursue felony prosecutions for that. But we just have to be aware of what we're doing when we start tweaking statutes. So, thank you.
Yes.
Representative Filer.
Mr. Chairman, could we also maybe, under those same lines, because it says regardless of cost, but there's many things that create a felony by cost in our state. So maybe, is there a way, maybe, that way somebody's not getting a felony for stepping on some flowers, right? But maybe actually put something in there, they're knowingly coming to do harm to your property, whether they're a squatter, and stuff like that, but they deface your property, but it was only $300 in damage. Should we throw $10,000 and 10 years of prison for that? Or should we recreate that dollar amount like we do on so many other statutes? It has to be so much dollar amount before it becomes the felony side.
Yeah. So Representative Filer, so under the theft statute, property over $1,000, if it's stolen, becomes a felony. And under existing damaged property statutes, property over $1,000 is damage. So what we're talking about here are damages to a property caused by a squatter where the damages are between $1 and $999, because everything over $1,000 is already a felony crime. So the question before us would be, is a $25 window worth a 10-year felony? Or do we pick some other dollar limit someplace in between? Or, in most of these cases that I've heard of, the damage clearly goes above $1,000. They're tearing the copper pipes out and the copper wire and all sorts of massive amounts of damage. But the question is, somebody leaves muddy footprints on your carpet, is that going to be a 10-year felony? All right.
Mr. Chairman, I'm sure amenable to fixing that if you think that's a problem we should address. I'm wanting to get the squatters out. The damages can be whatever. Thank you.
Thank you very much. So committee, let's take a look at the bill. It is a committee bill, came out of the interim. It enjoyed widespread support within this body down the hall. So you have before you the engrossed version. I know you've all had an opportunity to read it, so I don't know if we need to go through it item by item. But if there's any, yeah, we're going to take more testimony. I'm just introducing the bill to the committee. And since it is a committee bill, the senators kind of set the stage generally. Members, if you have any questions about any specific language within the bill, perhaps the senator or I or Representative Chestick can answer any of those questions. Any questions about the bill itself? Okay, seeing none.
Mr. Chairman, thank you.
Anyone else in the room wishing to testify on Senate File 6? Morning,
Thank you,
Ms.
Mr. Chairman.
State your name for the record. And tell
Lori
us yourself.
Urbakite with the Wyoming Realtors, and we are very supportive of this bill. And as the good senator pointed out, we did survey our members across the state. And not only is it happening in most every community, but it's also happening in remote areas like cabins in the mountains up above some of our pretty scenic areas. So it is widespread. We had a young lady from Park County that was a new agent, new licensee, and she went to what was supposedly a vacant home. It had been foreclosed on, and the original owners had moved out, and somebody had moved in, and she had no knowledge that there was anyone there. So it's also a safety issue for our agents, not knowing who they're gonna find, where, what, when. And again, I would reiterate that the felony issue, the fine, trying to decide what that property value should be, stepping on someone's pansies in their front yard. We want to get the squatters out. That's the goal. How you deal with that other stuff, it's up to you. That is not a concern of ours. We're not going to be able to collect from them anyway. As you know, I own rental property, and we had people stole the stove and the refrigerator and totally trashed the entire house. Yeah, I've got a judgment against them. They don't have any money, and I'm never going to collect from them. And so the issue is getting them out of the house. That's the primary goal as far as we see it. And I'd be happy to try and answer any questions.
Representative Bratton.
Thank you, Mr. Chairman. So I listened to your testimony this summer during the joint Judiciary Committee, and you had some concerns about the language in the bill that was related to open houses and the importance of keeping the bill focused. And I want to know if the language was changed to address your concerns.
Mr. Chairman. Yes, it was. We also had concerns. There was a clause in the bill, and as it came out of committee, there was a clause in the bill that required the owner to identify when they acquired the property. Originally, it said when they purchased the property, and I had concerns with that because sometimes people don't purchase it, they inherit it. And then when they acquired it, and I started doing some research trying to figure out how you find out when that property was really acquired. My husband owns property, and so I went back and if you go to the mapping system in the county websites, some of the counties, you can find a little column over here on the right side that will tell you supposedly when the property was put in that individual's name. Well, I found one rental in Casper. It had the date that seemed feasible to me. The next one didn't have any date. The one on his family farm that his parents homesteaded said that he purchased it in 2010. And I mean, it's just, so I had concerns about what difference does it make? If you can prove that you own the property, you're the owner of the property, what difference does it make if you've owned it for a year or 2 years or 3 years? There was concern about that it could be a holdover tenant, but this bill specifically says if they were a previous tenant, this doesn't work. You got to go through the forcible entry and detainer eviction process. So they did remove that language, and I approved it. The other thing they removed from the committee bill was when it talks about after the person is removed, the owner can ask for the law enforcement to stand by so they can get the property out, the other person's property out of there or whatever for safety issues. And there was a provision in there that the law enforcement agency could charge a reasonable fee. And that was taken out because the Senate committee firmly believed that that property owner had been damaged enough that they shouldn't have to pay law enforcement to stand by and make sure they were safe. So that's kind of the changes that were done in the Senate committee.
Representative Lean.
Thank you, Mr. Chairman. Thank you for coming today. My question is around previous tenants. So if we have a tenant that say they've been out of the premise for a year, maybe 2, and then they see that the home is vacant and they come back in, does this solve that squatter problem because they were a previous tenant, or does that open a door for a new problem?
I think this does not solve that.
Ms.
I'm sorry, Mr. Chairman. I think that does have an issue, but we wanted to make certain that we weren't, we didn't, if they were a holdover tenant or they had been a tenant and they just didn't want to leave, we got to go through the regular process of forcible entry and detainer and the eviction process. And so that's why that previous tenant's in there. It always just kind of bothered me a little bit, but I don't know how we get around it.
The discussions I remember in committee was a desire not to bypass existing landlord-tenant law, that would just unduly complicate this legislation. Further questions for Ms. Urberkite? Thank you for
Thank you,
being here
Mr.
this
Chairman.
morning. Good morning.
Mr. Chairman, Committee, Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this legislation. What we're finding out is we're not as isolated as we used to be. A lot of my members have housing that they'll only use for a seasonal need, like for during the birthing season. The rest of the year, the house, the dwelling will stay empty. Then they're going back, and some people are finding, well, there's somebody been living there. So this is a good bill. We support it. It'll help my members out. And it kind of maybe just a sidebar, I would appreciate working with the senator, the committee. You know, they mentioned they did not mention agricultural property, and I'd like to be on that discussion. That's a discussion for another time. But sitting in support of this bill, one more comment on about the punishment. Just as a note, it's an up to. There's not a minimum sentence. It's up to the 10 years, up to the $10,000 fine. So to me, that it's still a felony, but it does leave some discretion to the court system. With that, Mr. Chairman, supporting the bill, I would take any questions you or the committee may have for me.
Thank you, Mr. Moline. Any questions for Mr. Moline?
Thank you.
Always good to have you in House Judiciary.
Thank you. It's nice to come support a good bill.
Thank you. Mr. Carenti?
Good morning, Mr. Chairman, committee. I'm Joey Carenti. I'm the Executive Director of Rural Wyoming Matters. We're an informational, educational, and advocacy group throughout rural Wyoming. I'm going to kind of lean into our representatives on either end of the dais here because I don't know where everybody lives. But there is a concern across rural Wyoming that's not just agricultural. The question earlier about does this mean the flowers in the front yard? That's assuming that this bill only applies to property that has real property on it or a dwelling. Where I live, we have multi-use property that I own. Some of it's for grazing. We also use it for hunting. It's blank, and if anybody comes on that property, and this has happened in the past, it's not just damage to the property or dwelling. They tear up fence, they ruin gates, they screw up our wells. And I can't produce to the court a receipt saying, this is what I had to pay somebody. These are my actual damages, because we're rural Wyomingites. We fix that ourselves. And that's what the court wants. They want to see an itemized invoice of what those damages are. Most of the time, I just got to go out to my shop, pick up some wire, a couple of pipe fittings, and go fix it myself. But my time has value. So I would caution any conversation about saying let's limit it just to a specific or physical dwelling. Maybe this is an interim topic of how do we include bare land, land that only has basic utilities but no dwellings on it, or agricultural land. But another thing I heard from a earlier testimony with the real estate association, they realize that sometimes it's just going to be, we're going to fight them in court, the court's going to charge them a fine, that goes to the government, and then there'll be a restitution hearing and we may never get that money. I don't want to step away from being able to say these are my actual damages, and the court should recognize that, because in the future that individual might come into a windfall, or the state might owe them something. And there are already laws on the books that say we are going to check all liens and court judgments against you before we release this money to you. And the people of rural Wyoming already have a hard enough time if they're using their property for camping, hunting, all these other things, making a little bit of extra money to survive. And for them to never have a path forward to possibly reclaim that money, that's problematic. So on and for the bill, I've testified on it before. I think it can be added to in future years, but don't get locked into maybe what many of the members are used to. We're not talking about apartments or houses only in cities. And with that, I stand for any questions.
Thank you. Questions, Representative Fowler?
Thank you, Mr. Chairman, Mr. Committee. With that, I totally understand that rural side of it because I own some rural property. Right now, I think we would have to go through the trespass statutes for what's being done on what you just explained. But I do believe, I think a lot of us are open to expanding this definitely to ag, to, commercial and other stuff, maybe an interim topic. But I do believe we do have trespass statutes that do help with that. Because if they're just trespassing, they break a fence, they're not squatting, right? They're not planning on living on that field. So I think we gotta kind of intertwine both those laws and make sure something fits, but I'm willing to work with you on that.
Mr. Chairman, Representative Fowler, I would agree, and in the green books, there is plenty of stuff, but let's talk about a situation I didn't want to necessarily bring up, but rural Wyoming, during hunting season, somebody's got a state-issued tag, and I say, wait a minute, you're on one of my non-adjacent properties to my main property, and you set up an RV, you set up a campsite, and I call the sheriff. Sheriff pulls up, I have a hunting tag for this area, and I've got this note in my pocket where he gave me permission to be here. There's a series of laws being proposed about squatting, providing false documentation, but the amount of time it takes me to get that person off of my land so that we're not putting law enforcement in jeopardy for violating, hey, is this not? That's why this series of laws, I think, is so important, specifically to rural Wyoming. I would agree, what we have on the books should be good enough. Unfortunately, in some realistic situations that have happened, it's just not.
Thank you. Appreciate you being here this morning. Anyone else wishing to testify on Senate File 6? We're coming up on 9:30. Mr. Thompson, welcome.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Chiefs and Sheriffs Association. We've been part of this discussion for several months now, and I think we're in a place where we can comply with anything that's asked within this bill. I know that there's some discussion about the application of that damaged property portion added at the end of this bill. So on page 11, if you look at that section starting on line 16, when you go down to line 19, it's talking about if the person unlawfully detains, occupies, or trespasses upon a residential dwelling. I think if you delete trespasses and just put if the person unlawfully detains or occupies, it should cover what I think the intent of the bill was. When someone is unlawfully detaining or occupying, trespass does exist. If someone trespasses and damages property, there's existing law that could be used to apply there. Like if someone walks across that lawn and steps on the flowers, it might not be a trespassing because they weren't given notice that they couldn't trespass, but damaging someone else's property could be a crime and fit within that misdemeanor and felony threshold that we're used to in the property destruction section, but yet still carving out somebody that unlawfully detains or occupies a residence and then causes damage, that could be a consideration. But other than that, Mr. Chairman, I'd be happy to answer any questions you might have about the bill in general.
Thank you, Mr. Thompson. Just want to say thank you for all your work over the interim. With these committee bills, they morph over time. There's a lot of ideas, and that committee process over the interim really pays dividends in bringing disparate viewpoints into a cohesive piece of legislation. So thank you for your support. Questions for Mr. Thompson? Representative Bratton.
Thank you, Mr. Chairman. Mr. Thompson, so thank you for coming in. I did follow your testimony during the joint interim committee. And as I looked at the trespass and I thought, well, okay, we already have trespass, but it sounds like this may be a little bit of different tool in the toolbox if we take out the trespass, and amend that as you just suggested. Would changing that language give you two different options to deal with potentially different situations, and that would be helpful to our law enforcement? Am I reading that correctly?
Mr. Thompson.
Mr. Chairman, I think that actually narrows that choice between two. I think the existing language on page 11 gives us those two options right now with dealing with trespass, because trespass is mentioned here, and trespass is a separate crime that still will exist. And it makes it a component of this. And then, I mean, maybe that even calls into question, do we have to, well, I don't know, you could go with detains or occupies. It just adds another leg to it. I'm just suggesting that if you're trying to limit it specifically to someone that's unlawfully squatting on a property and damage occurs, maybe removing the trespassing, and that's obviously a policy decision. I'm just trying to help here. As it stands either way, I think we have options. With this whole bill, we still have the option to address it as a trespassing from the get-go. And maybe the knock on the door and the identification that the person shouldn't be there, then they're told to leave if they haven't already been told to leave by someone else, and they pack up their stuff and leave. And this is over. And we don't even have to go through this process of this bill. But I think the idea of this bill is somewhat helpful when we get into the question of whether something is a civil issue or not. It gives the property owner another avenue to compel law enforcement to do something when the boxes are all checked on the checklist in this bill. Mr. Chairman.
Okay, thank you very much for being here this morning.
Thank you.
Anyone else in the room wishing to testify on Senate File 6? Anyone on Zoom? Going to close public comment. Committee, what's your pleasure? Move the bill by Filer, second by Vice Chair Singh. Any proposals for amendments? Representative Filer?
Mr. Chairman, with this previous testimony there, I think that if we do that, page 11, line 19, and we strike or trespass, I do believe law enforcement wise, that it gives them that discretion too, helps them with that discretion. Also, it keeps that kid that walked over the flowers probably out of jail. You know, I mean, so I think that way they can use the trespass statutes or this. So I would make that amendment to scratch on page 11, line 19, or trespass.
And I'll second that. Motion by Filer, second by me. I don't think it's necessary. I think
No, detains
unlawfully,
or occupies.
Detains or occupies. That does make sense, Mr. Chairman.
if the person unlawfully detains, occupies,
Or occupies.
Yeah.
or occupies, going to insert the word or,
Right.
and then delete or trespasses.
Yes, sir. Yes.
So we're going to insert the word or before occupies and delete or trespasses on line 19, page 11.
Also delete the comma after detains.
Delete the comma after detains.
No, that's fine.
Upon should stay, I think. Yes.
Occupies upon, yeah, that's fine. All right, everybody good on what the motion is? Discussion on the motion? All those in favor say aye. Aye. Those opposed, no. That amendment is carried. Further amendments? Seeing none, let's call the roll.
Representative Brady,
Aye.
Representative Bratton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washington.
Aye.
9 ayes.
Any volunteers to carry the bill on the floor? Anybody not had an opportunity to carry a bill yet? Representative Filer, it's all yours. We'll back you up. Thank you, everybody. We'll see you on Friday.